Hello and welcome to Legally Speaking with me, Tarun Nangia. Justice C.T. Ravi Kumar and Justice Sanjay Kumar have issued an order which will have a far-reaching impact. The order is that they have, in the order, directed the high courts all across the country, each high court of the country, to list bail applications at the earliest. And they have shown concern that personal liberty is at stake and high courts must treat personal liberty as matter of utmost priority. This is a very strong message from the Supreme Court of India and a much needed message that the two honorable judges have given, something that should be applauded and followed through by the high courts. We will like to see what happens now that this message in writing has gone to all high courts. I have a very eminent panel who will discuss this order with me on the show. Let me welcome Justice R.S. Chauhan. Sir has served as the Chief Justice of Uttarakhand High Court. Good to see you on Legally Speaking and looking forward to some interesting insights. I have with me Senior Advocate Geeta Luthra, leading name at the Supreme Court of India on the criminal bar side. Good to see you, ma'am. Looking forward to some interesting insights. I have with me Malak Bhatt, founding partner of NM Law Chambers, one of the leading names in the financial crime side in the Delhi High Court and the Supreme Court, with one of their recent successes being bail for the M3M promoters. Congratulations for that big order, and looking forward to some interesting insights from you as well. At the outset, let me request Justice R.S. Chauhan that in the first 2-3 minutes, if you could give us a brief background for us to understand the implications of such a communication coming from the Supreme Court, what impact does it have, and so on and so forth. Over to you, sir.
Thank you, Tarun, firstly for inviting me on your program. To begin with, what the honorable judges have said in the case of Kavish Gupta versus State of Chhattisgarh, it is a reiteration what the Honorable Supreme Court has been saying from the days when the Supreme Court had decided the case of the state of Rajasthan versus Balchand alias Balia, that number one, bail is the rule, jail is the exception. But over a period of time, if you look at the statistics are extremely glaring. Unfortunately, we do not have the availability of the latest statistics of 2023. But let me just illustrate how glaring the statistics are. If you look at the Dutch report of 2022, which is last year, it tells us that there are 130,000 bails pending in the high courts. It equally tells us that in the district court, the number is 196,861 bail applications pending in all the district courts. Now, that is a huge number we are dealing with, number one. Number two, there are certain practical problems that any Chief Justice is bound to face. With this large pendency, many, there are high courts, for example, the Patna High Court, which has more than 4 benches occupied just to bail matters. In Rajasthan, we have at least 3 benches. Earlier, Patna used to have 6 benches occupied with bail matters. So you're talking about a huge number. Now, the question is, why do we have such a huge number? There are many reasons. Number one, if you go to the Judicial Academy, you'll find, to your horror, that most of the judicial officers who are under training are taught by the judicial academies not to grant the bail. This was horrifying for me when I visited the Rajasthan Judicial Academy in 2014. And one of the trainee judicial officers asked me very frankly, he said, "Sir, are we permitted to grant bail?" So I said, "What do you mean?" "Of course you are. That's what the CRPC tells you." He said, "No, sir, the director sitting right next to you tells me not to grant bail, otherwise we'll get into trouble and our service record may be marred." Now, with that type of mindset from day one, if you could have it the judicial officers, do you think that the district judiciary will ever grant the bail? The answer is no. Number one. Number two, the consequence of that is that large number of bail applications have to be filed necessarily before the High Court. Now, High Courts are unfortunately, they have a dearth of judges. Now, with 13 judges in Telangana, while I was the Chief Justice there, how many bail benches can I create? I have a complete high court to run to. So therefore, the cases get, backlogged at the high court level. Now, consider the fact in 2019, 2020, the Honorable Supreme Court had 20,745 bail applications being filed before the apex court. Now, with that many number of bail applications being filed, how do we expect our Honorable Supreme Court to deal with it? Therefore, we have to restructure A, the mind of the judiciary, B, you have to strengthen your judiciary if you want any relief from the judiciary. C, you have to bridge the gap between what is being told to us by the Honorable Supreme Court and what we see as the yardstick or standard being set by the constitutional courts. Now, in some cases, ironically, it seems like some people are created more equal than others. In case of Arnav M. Goswami, the present Chief Justice had noted that unless we interfere, we are on the path of destruction of personal liberty. A very strongly worded thing and very rightly said so. But then the question is, then what happens to the other bail cases? In other bail cases, are we also not, in case A, we refuse to interfere or grant or adjourn bail applications, are we not on the path of destruction of personal liberty? Therefore, what we are being told and what is being acted upon, somebody will have to start bridging that gap. We can't go with this feeling others. So these are the various reasons why we need to restructure our judiciary and change the mindset of the district judiciary and make them courageous enough.
Thank you for sharing these insights. I have with now Senior Geeta Luthra joining us. And ma'am, you argue before the Supreme Court, the High Court and other forums regularly. When you saw that Justice C.T. Ravi Kumar and Justice Sanjay Kumar issued such an order, sending a strong message, your first reactions to that action by the Supreme Court?
So I'm very happy. Any lawyer, particularly any defense lawyer, and I think I have defense lawyering in my blood. So I've been counsel for the state, but the defense lawyering is in the blood. It's natural. And I think it's natural for anyone who believes in civil liberties, who believes in human rights, that this defense mechanism comes naturally to you, that there are human rights. There are rights also of the accused. So all the time we keep thinking about this. So this judgment's very welcome. But we must remember that in Satinder until, same note was set by Justice Sanjay Kaul, who's just retired, demitted office, but gave some beautiful lines in Until's case in beautiful directions. Before that, I remember in Dattaram, Justice Lokur's bench gave some beautiful directions, which we used to keep quoting all the time. And before that, I remember another judgment, that is Sitaram Maitre. Justice Dalveer Bhandare was the author. And it stood out, all these judgments stand out for human rights. So when we read something like this, I only hope that this will strengthen the judiciary, that if we give bail, it's not that somebody will pass strictures. There has to be a confidence that if I give bail on the principles of Arnesh Kumar, on the principles of these three judgments, on the principles of 1980 Gurbakht Singh Sibya judgment, which my father used to recite, and I used to be awestruck because, as young children, you're not used to getting judgments rolled off with their citations. But you saw that coming from criminal lawyers because there were these few judgments which were constitution bench judgments, citadels of our democracy. And I think this strikes the right note, the judgment of Justice Ravi Kumar and Justice Sanjay Kumar. I am so happy about it. And I hope that all the courts will take leaf out of it. Well, of course, every case will depend on its facts. There are many of those aspects we have to look at. Cases above 7 years imprisonment, Arnesh doesn't apply. And therefore, sometimes now the police adds 409 to everything. They'll add some other section to everything. If it's an injury, they may add attempt to murder in that. So we have all those interesting little things so that bail gets rejected. But the court has to look and separate the straw from the chaff. It has to look as to what is the meat of the case, what are the meat of the allegations. That's
point well taken, ma'am. I'll go to Malak Bhatt, founding partner, NM Law Chambers. Mr. Bhatt, your firm has represented some of the biggest names who have been accused in ED and other financial crime cases in the past 6 months, if I may say so. You understand, therefore, the importance of bail because you do client facing on one end and who wants bail. And then you have to convince the court that your client merits bail. Given that fact, what is the message in your view going from Justice C.T. Ravi Kumar and Justice Sanjay Kumar to the High Court? And if you can also evaluate the importance of such a messaging actively given by the Supreme Court of India.
Yeah, absolutely. Thanks, sir. So I think I first take you from what Geeta ma'am said, that during Satinder Kumar until his hearing, in fact, Justice Kaul made a comment that unfortunately the Supreme Court is turning into a bail court, where every bail matter is ending up reaching the Supreme Court, which was A, never envisaged, B, never anticipated for the Supreme Court to actually start hearing so many bail matters. And one very important message that this order by Justice Ravi Kumar and Justice Sanjay Kumar reads in is deprecating the practice of admitting bails and keeping them pending for uncertain periods of time. So in fact, if you see, tie these two things in, why do the bail matters reach Supreme Court is because of A, the reason which Justice Chauhan also gave, that bails are being rejected outrightly because no one wants to take that risk upon themselves. B, or the bails are kept pending for such a long time that the person who is suffering incarceration feels no other option left but to go to the higher forums to at least get some certain order for himself. So if you in fact see the order which was challenged before Justice Ravi Kumar in this matter, it was an interim order which just said issue notice, admit the bail and call for the records. Now, various high courts follow this practice where bail matters are then kept pending in limbo for a very long time without seeing the light of day. So an interim order reaching the Supreme Court by way of an SLP for the court to actually come down and say, look, you need to hear these matters is nothing but a clear, strong reiteration by the Supreme Court that these are matters which have to be taken up expeditiously with certainty and a specific time frame. So in fact, again, coming back to until laid down specific directions to the courts below that any anticipatory bail matter has to be, no matter what, heard within 6 weeks, and regular bail matter should be heard within 2 weeks. So if courts have to really follow this, then this practice of admitting bail should in fact go. In fact, very recently, the Gujarat High Court, Justice Sunita Agarwal, currently who's the Chief Justice, has taken a conscious decision and has come out with a memorandum that no bail matters will ever be admitted by the courts. Every bail matter will be heard given a fixed date. The idea is not that you will be granted bail the moment your bail application is being heard, but the very fact that the bail matters kept pending in the High Court or at the trial court level for a very long time itself is a death knell to that person's liberty. And that's a very crucial line in the order that of Kavish Gupta, where the court says the very fact that the due application, the due consideration of the application is being delayed is a deprivation of that person's liberty. And today, the person who's facing incarceration, what he wants is certainty to his way forward. Does he need to go forward? Does he need to go and apply for bail at a higher court? What other steps should he take when the bail is decided? Till the time the bail application is pending, he's at a stare decisis. He's at a stage where he really can't move. And that itself is a very, very big blow to liberty, which I think the Supreme Court has very well addressed.
Point well taken. I'll now take this to Justice R.S. Chauhan. Sir, two things I want to ask you.
Yes.
The Supreme Court earlier also has, taken some steps with regard to bail. Satyendra Kumar, until the panelists mentioned, the Chief Justice of India also said that Supreme Court itself, every bench will hear 10 bail matters every day. And then again, this reiteration of Justice C.T. Ravi Kumar and Sanjay Kumar had to come. What happens that every 6 months or 8 months, Supreme Court has to remind the High Courts of this measure? Because you yourself have been, you were the Chief Justice of you understand this much better than all of us. What sets in that has to be then the Supreme Court has to then tell the High Courts, no, bail has to be taken seriously. What exactly happens? If you could share this with the viewers.
In fact, it's good that we are getting such directions from the Honorable Supreme Court, but the question is a practical one. It's one thing to issue a direction. It's another thing to how does one implement this direction? Now, the question will arise. If I do not have number of judges in my court, if you look at the High Court, look at the vacancies in the High Court. Almost, except the small High Courts like Sikkim, the rest of the bigger High Courts have at least 50% vacancies, if not more. Now, the question lies before the Chief Justice of each High Court is, how many benches can I devote to bail matters? Now, one of the ways to declog your High Court is to protect your district judiciary. Unfortunately, over a period of 2 decades, we have systematically demoralized our district judiciary. If a district judge were to grant a bail, let's say in 302 or 304B or 376, chances are you will be flooded with complaints against the district judge. Now, no district judge is going to risk his service career by granting a bail. So what does he do? He rejects that bail. The bail comes to the High Court. Therefore, the first and foremost thing we need to do is to protect and to encourage our district judiciary to grant the bail. Number one. Number two, you need to have more judges in the High Court. If you don't have judges, there's no way we can devote too many benches. And this is unfortunately the bane of most of the High Courts. Number three, I agree that the guidelines have been repeatedly given by the Honorable Supreme Court. What are the criteria one needs to keep in mind while granting or refusing to grant a bail? But again, it's a matter of the precedent being set by the Honorable Supreme Court. Many times we find that where I may think that, yes, the bail should have been granted, unfortunately, the Supreme Court has a different or contrary view. Now, then I wonder as a judge, that am I wrong in my thinking that bail ought to have been granted? Or do I just bow to the observations of the apex court? So this is what I'm saying, that if the apex court is beginning to speak, there's a bridge, gap between what it says and its action, then it leads to contradictory signals being given to the High Courts and to the district court. So there's bound to be some confusion in the judicial mind in the High Court and the district court, and then you can't blame us.
It's a very fine observation made by you, sir. It will force us to think or rethink what we were thinking.
I'll give you just one example. In Telangana, there used to be a division bench order passed in a criminal appeal. Can you believe that order said, ordinarily, in a criminal appeal, bail should not be entertained for 5 years, for the first 5 years, which came as a rude shock to me when I reached Telangana. I said, certainly the Andhra Pradesh High Court has amended the CRPC. Now, where do you get this order from? And when I said, no, I'll grant the bail, people were shocked. They said, how can you grant the bail? It's a division bench order. I said, I'm sorry, it says ordinarily. I would tend to think it's an extraordinary situation where I know that the criminal appeal is so good that it is a case that will lead ultimately to an acquittal. Then what is the need to keep that person behind bars for first 5 years?
Point very well taken. I'll take this to Ma'am Geeta Luthra. Do you see difference in attitude towards bail because you also go to various high courts to argue bail matters?
Yes, I think there's a huge difference. I think, for example, the Delhi High Court, I find, is far more liberal. I think maybe it's the proximity to the Supreme Court that makes us more amenable to hearing what the Supreme Court is saying. So I see that our courts in Delhi will be far more cognizant of Arnesh Kumar. Whereas I travel to various high courts, and I can't name them. Justice Chauhan's also listening. I can't name them, but a lot of them say, how much? 3 months? 4 months? All right, come again in February. We'll hear you then. And of course, the conscience in me sort of dies. I say, you may have less paucity of judges. You do have paucity of judges. But that day when the bail comes up, decide it one way or the other, or say that you have not gone enough time and this is a heinous or serious offense, and therefore we are reposting it after 2 months. It cannot be cavalier. And for example, you take simple case like 498A, 406. You take simple case of cheating. Just take these two examples, for example. I'm not saying Prevention of Corruption Act. I'm not saying other cases. 498A, 406 cases like Delhi would normally be giving you bail. But I've seen people languishing. And I've seen after languishing, they go to High Court. High Court doesn't give bail where the offenses are, where the allegations are. You can see that they are half made up. Then we go to Supreme Court. In Supreme Court, you have 10 minutes, 10 seconds, 30 seconds. You may be lucky. Your point may go home. It may not. And then you are languishing for another 5 months. Now so all the high courts, I think Telangana would be more liberal. It depends on the high court, I think. It depends also on the ethos of the judge. So, as even in Supreme Court that they say there are many Supreme Court, each judge has a different view. There'll be conservative judges, there will be liberal judges. Similarly, in the high courts, you will have that. Now, 420 cheating cases, many of them are contracts converted into cheating cases. So many courts will say, look, this is a simpliciter contract, but if the amount is huge, obviously the courts take a more serious view. But sometimes I think to myself that for the poor man who's been cheated of 100 rupees, his 100 rupees is as important as a rich man's 100 crores. So the question is, you can't just look at figures and decide this. And I feel we have to be very empathetic, take both viewpoints. There will be,
Point.
So when you say, have you looked at various high courts? I've seen at various high courts, within the same high court, I have seen various judges. And I think sometimes those who are very liberty trained, who are very, or whose mental ethos even otherwise is very pro-liberty, pro-human rights. I quote from Magna Carta, if you permit me, one quote. No free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do, except by etc., the law of the land. You're talking of 1215. That was how the bails law came. And I feel we have to keep reminding ourselves of this.
Point very well taken. I'll go to Malak, but Mr. Bhatt, quickly, two things I want to ask you. Firstly, from Supreme Court, you're of course successful in getting bails for a lot of your high-profile clients, but that was from the Supreme Court, which means you had to go up to the Supreme Court. Second, I want to ask you that many times when bails come up, they're actually pleading that if I were to be convicted, I would have been, say, convicted under PMLA for 7 years. I spent already 3.5 years and now grant me bail. So why things come to such a pass that people spend half of their conviction terms without even the trial commencing? What is happening really?
So I'll answer this in two ways. There are, I think, predominantly two reasons if you take cue from what Justice Chauhan and what Geeta ma'am both said. One, somewhere the judges start from the trial court till the Supreme Court need to introspect on the counterbalance between the allegation contained in the charge sheet or the complaint vis-a-vis the fact that you are still at a under trial stage. By merely taking the allegation to be gospel truth, if one is to sit down and start his defense, you are completely turning the law of bail on its head, even if there are higher conditions or stricter conditions of bail imposed, because at the end of the day, what you're looking at is that person going to at least reasonably be able to justify his case from the charge sheet which is filed against him? B, are there ways to secure his presence at the stage of trial? The whole purpose of arrest was the power to utilize and to conduct a free and fair investigation. Today, we are reaching a stage where the allegations against him are raised at a level where the person in the notions of the court and in the notions of the public already stands convicted by the very fact that there's a complaint or a charge sheet filed against him. So he is then required to meet the pedestal of trying to show as to how, even put to the hilt, the case which is put up against him is not made out. Which brings me to my second reason. Very interestingly, Justice Kaul made this comment in one of our other matters where he said bail argument should not be more than 5 minutes and a bail order should not be more than 2 pages. Unfortunately, and as Justice Chauhan pointed out, that the temperament from the lower court today is that I will be castigated if I give bail in a let's call it a high profile case. We are seeing lengthy arguments on bail being commenced from the trial court, which go up to the High Court and even in the Supreme Court, which should never be the case. Because ultimately what you are doing is you are rerunning a trial which is to take place probably 2 years from now. But at the stage of bail, the person, the lawyer, and that's the expectation from the judge, that you are required to meet each and every allegation and try and prove your defense at that very stage. So we have seen matters where the bail arguments go on for days on end. And that's one of the reasons why, because of bails, obviously more and more arrests are happening, which is why more and more bails are being filed. Till the backlog is not cleared by hearing matters over 3, 4, 5 days, the newer matters will never be heard. And these bails just keep rotating, which is why you end up with a huge clog where either the hearing just goes on elongated and the judge kind of gets too much into detail, practically leading to a 50-70 page judgment on just bail, where at the end of a 60-page judgment, finding everything against the person, the last time we'll say this is only at the stage of bail. But what you practically done is you have expected the man to do a mini trial at the stage of bail. So while the Supreme Court keeps reiterating that, look, at the stage of bail, one is not supposed to go beyond a prima facie stage. One is not supposed to conduct a mini trial. Practically on ground, what is happening is exactly that. And I think that's the notion which needs to change. And that's probably one of the hints you can take from Justice C.T. Ravi Kumar's order, that you hear the matter. And the way you can hear the matter is by hearing it quick, by hearing it as if it's a bail, and by deciding it as if it's a bail. Don't go beyond the scope of the jurisdiction that is granted under these sections.
If I may just add, Tarun, if I may just add something that Mr. Bhatt just said. I think the other thing is that we need to remind ourselves, the judges need to remind ourselves that there are two sides of a bail application also. Number one, we have to remember that bail applications are intrinsically connected with the concept of personal liberty. Number two, we have to remember the first principle of common law. Every man is presumed to be innocent till proven guilty. Number three, we also must look at the consequence of denial of bail. Only recently, Times of India has published the data which shows that most of our prisons have more population, 163% more population than they can tackle, than they can handle. Now, this is what is happening to the consequence when you deny bail, especially when you start denying bail in petty matters. I mean, sitting in High Court, I've had bail applications being filed because somebody's camel or somebody's goats or somebody's water buffalo got stolen. Now, if that type of bail has to come all the way to the High Court level, then I really wonder what is happening at the district level. That is why I'm saying that we have to change our mindset about bails. And surprisingly, if you read some of the report, even the police is of the opinion, 83% of police officers believe that once an FIR is filed, the person deserves to be punished. And the way to punish him is to keep him incarcerated. Now, if that is the mindset of the police, and this is a mindset that is now beginning to percolate, perhaps even in the mind of many of the judges, then God help us all. I agree with what Ms. Geeta Luthra has to say, that we have to see this as part of human rights. It's not just something limited to the parameters of criminal law. Try to take a constitutional or a human rights view of it. And I think that is what is required now.
Thanks. Thank you for sharing your insights on the show today. Each panelist brought his own expertise on the subject. All of you have represented some of the most high-profile clients. Also, in one case, one of our panelists, Justice Sean, has been the Chief Justice, so he's seen how things are at the other end. So we could get a complete picture. Next month in January, we will take up the cause of bails again, given the sheer number of people that are waiting for one. And of course, the Supreme Court in this case has been encouraging. But I really appreciate Justice R.S. Chauhan, Senior Advocate Geeta Luthra, Malak Bhatt, founding partner of NM Law Chambers. You took out time and joined us, and viewers for joining in too. Thank you so much.
No, thank you for inviting us. Thank you, Tarun.
Thank you so much.